Hello, I'm Ron Mackey coming to you from the city of Las Vegas, Nevada, with the eighth reading from my book, Parenting the Bottom Line. I'll begin at the bottom of page 51. There has been an update on the subject of juveniles serving life without parole. According to an article by Liliana Segura in Alternate dated May 18, 2010, she stated that the U.S. Supreme Court has given a second chance to juveniles serving life without parole for non-homicide crimes. She goes on to say that children who commit crimes other than murder can no longer face a sentence of life without parole. The U.S. Supreme Court ruled Monday in a highly anticipated decision that civil rights lawyer Brian called an incredibly important win for kids who've been condemned to die in prison without parole. According to the article, Justice Kennedy drew a parallel between the death penalty and life without parole, noting that while it is true that a death sentence is unique in its severity and irrevocability, life without parole sentences share some characteristics with death sentences that are shared by no other sentences. Now, as previously stated, one of the main problems in our society is that some parents want to be best friends with their children, rather than face the difficult and responsible role as parents. This very loose and liberal approach to parenting has caused a world of problems in many families in America, as well as a host of other countries. If you don't believe me, ask some of the parents who have allowed this practice, and also ask them how easy is it to correct discipline or to say no to that child who is treated as their best friend. The root of the problem in so many households is that the parents are either too lax with no discipline in the family or too strict or harsh with their children. And the children of the parents who are overlax or overstrict will most likely get into trouble. Many children possess a deep desire to live in a structured household where there are set limitations and boundaries for them to follow. Believe me, if you as parents don't set limitations and boundaries for your children right from the start, and enforce them, your children will be following the rules set by your local correctional institution at a future date. Then it will be too late for them. Now, please keep in mind that there is no one-size-fits-all guide to parenting and discipline. But the ultimate goal for parents should be to raise their children to be mature and productive members of society. And along with their God-given parental role is the responsibility of the parents to apply moral guidelines and disciplinary strategies, which every newly married couple should negotiate with each other prior to having children. Now, these disciplinary strategies may include timeouts, grounding, removing of privileges, or even spanking as a last resort, if and only if all other corrective measures have been exhausted and behavior has not improved. There was a survey of more than 1,500 parents in 27 states, Canada and Puerto Rico, recently conducted by the Pediatric Academic Societies in 2005, which gave a behind closed doors look at how parents discipline their children. In this survey, parents responded to the form of discipline most used by them, and the results are as follows. Timeouts, 42%. Removing privileges, 41%. Yelling, 13%. And spanking, 9%. Sending to bedroom, 27%. This survey was given to parents of children aged between 2 and 11 before the children's well-child doctor visits. According to this survey, punishments were often tailored to the child's age. Timeouts and spankings were reported more often for disciplining little kids aged 2 to 5, and older children were more likely to get privileges removed, be yelled at, or even hear the old classic line, "Go to your room." Now, according to the article, many parents are following in their parents' footsteps. In the survey, many parents were asked to recall the disciplinary strategies their mothers and fathers used on them in childhood. Their answers mirrored their own methods. That is, parents tended to duplicate the type of child discipline they received from their own parents. Sherry Barkin, MD, one of the survey researchers of Brenner Children's Hospital, part of Wake Forest University Baptist Medical Center in Winston-Salem, North Carolina, stated that the only form of parental discipline experienced in childhood that was not significantly associated with the current choice of discipline was spanking. And this survey showed that children often grow up to practice the same methods of discipline that were used on them. This again proves why it is so important for parents to discuss and agree on disciplinary strategies with each other prior to having children, so that there can be a team effort and a sense of direction that can guide them in their sometimes difficult art of parenting. Do you recall the dilemma of little Tommy's mother in the opening pages of this book? She was once told that if she spanked her erring child, she could be arrested for child abuse. What is not correctly understood by most people is that the law concerning the use of spanking as a form of discipline. I spent quite a bit of time researching state statutes and found some interesting facts concerning spanking or corporal punishment. It is a fact that it is legal in all 50 states for a parent to spank, hit, paddle, whip, or even otherwise inflict punitive pain on a child, insofar as the corporal punishment does not meet the individual state's definition of child abuse. A few years ago, the Oklahoma State Legislature amended their child abuse laws with a bill that explicitly granted parents the right to use paddles and switches to spank their children. The bill was enacted reportedly in response to the Columbine High School killings in Littletown, Colorado, and to broaden the rights Oklahoma parents already had to spank their children under current laws. My state of Nevada passed a similar bill, and the law in the state of Alaska states that the parent guardian may use reasonable and appropriate physical force upon the minor when, to the extent reasonably necessary and appropriate to maintain discipline. And it just gives the state statute. Now, Georgia spanking laws state that physical forms of discipline may be used as long as there is no physical injury to the child. That's state statute 19-7-5/15-1/49-5-180.ci. So I won't read all these. I won't bore you with all those. I'll just read the other ones. Parent or person in loco parentis reasonably disciplining of a minor has no justification for a criminal prosecution based on that conduct. And that's state statute. The state of Michigan spanking law states that parent, guardian, other person permitted by law can reasonably discipline a child, including the use of reasonable force. The state of Arkansas specifically defines in its law the difference between spanking and child abuse by stating that abuse does not include physical discipline of a child if reasonable and moderate and inflicted by a parent or guardian for restraining or correcting a child. I'm going to stop right there, and I'll pick up again on page 58 for the 9th reading from my book, Parenting the Bottom Line. I'll leave it right there. I'll just say goodbye to you. Thank you for tuning in to Parenting the Bottom Line, and I'll see you next time. And may God bless you as you continue in your journey in the art of parenting. God bless you and good night. Thank you for tuning in.